On February 3, 2026, Jeffrey Oliver appeared for sentencing before Judge Aaron Gauthier in Michigan's 53rd Circuit Court after pleading guilty to possession with intent to deliver methamphetamine and tampering with evidence. Because Oliver has prior felony convictions, his case falls under Michigan's habitual offender laws. For a third habitual offender, someone with 2 or more prior felonies, the court is allowed to increase the statutory maximum sentence to up to twice what the law would normally permit. Those enhancements are authorized under Michigan law, including sections MCL 769.10 and MCL 769.11. But the length of a prison sentence in Michigan is also guided by sentencing guidelines. In 2015, the Michigan Supreme Court ruled in People v. Lockridge that making those guidelines mandatory violated the Sixth Amendment, because judges were relying on facts not found by a jury to increase minimum sentences. Since that decision, judges must still calculate and consider the guideline range based on the offense and a defendant's record, but they are no longer bound to follow it. In Oliver's case, the guideline range was high. However, the prosecution and defense reached an agreement to cap the minimum sentence at 72 months. Today's hearing was about one question: whether the court would accept that agreement and impose the sentence under Michigan's habitual offender and sentencing laws.
Here for sentencing on charge of possession with intent to deliver methamphetamine with a habitual third, 40-year statutory maximum with the habitual, and tampering with evidence, habitual third, again, an 8-year discretionary statutory max with the habitual. Guideline range on the principal offense scored at 78 to 195 months. There is a sentence agreement for concurrent sentencing with a 72-month cap and no absconding charge brought. Ms. McGregor, if you had a chance to review the pre-sentence report and recommendations with your client?
I have, Your Honor, yes.
And I also have had an opportunity to review your sentencing memorandum, including the attached mitigation memo. Do you have any defense objections or corrections to the factual information in the report?
There is a factual addition on page hopefully the court has the original and the updated PSIs.
Oh, yes.
Okay, so back in the original PSI for the descriptions on marriage narrative, family narrative, that starts at page 8. Down at the bottom, we would like Argyle Edwin Oliver added. Argyle, I'm sorry, did it again. He was born May 27th, 2025, and he is Mr. Oliver and his current fiance's child.
Okay, what is that child's name?
Argyle. And the spelling there is ARGEL, Edwin, EDWIN, and then Oliver.
Okay, and it looks
what's the birthday?
5/23 of 2025.
27, Your Honor.
5/27 of 2025.
You got it.
All right, and this was Agent Lesky prepared the updated report, but this is the report that's that was prepared in Chippewa County by Agent Butkovich. I don't know. I mean, I haven't had a case where somebody wanted to change the older report, but because it's attached to this one and part of the report that I'm sentencing them on, I think the court rule still applies for me to correct that information.
Yeah, and I mean, if it was something more minor, then, but I mean, it's a full child, you know what I mean, Your Honor? So it makes sense from my perspective to have that in there. Because if you look to the bottom on page 8, it says they do not have any children together.
Their report was written in December.
Oh, yeah. Do you know who represented them in Chippewa County?
I believe it was Miss France, and I was wondering that too, why that wasn't corrected at that juncture.
Okay. I guess let's handle it this way. That Ms. Goodrich, do you have any information about that thing?
I do not.
Well, let's handle this then. Agent Martin, if you would reach out to Agent Bakovich and have her just confirm that name and date of birth with the child's mother. And if it is accurate, make that change then.
Okay.
Does that suffice, Ms. McGregor?
It does, Your Honor. Thank you.
All right. Any other additions, corrections to the PSI?
No, Your
The
Honor.
guidelines were scored advisory at 78 to 195 marks. Any scoring challenges?
I don't have any scoring challenges. In terms of the time served though, Your Honor, I do think that's going to need to be updated.
Oh, well, interesting about that because on January 6th, he was sentenced in Chippewa County, right?
Yes, that's correct.
So actually I have in my notes to amend the jail credit to subtract 7 days
Okay.
because then he's not entitled to credit while he's serving another sentence.
Yeah, and that actually, him and I discussed that because, yeah, I was thinking that was an issue as well.
So that would bring me, by my count, to credit of 296 days.
Let me see what I have 296 as well, Your Honor.
Okay. And you said you had no scoring challenges?
I don't have any scoring challenges. I was though also wondering when I was looking at this, I can't recall when he was sentenced in Allegan, but technically he remained in Chippewa County.
All right, Ms. Goodrich, any additions, corrections, or scoring challenges from the people?
No, Your Honor.
All right, Ms. McGregor, anything you want to say on behalf of your client?
Yes, Your Honor, thank you. So I think as the court's aware at this point, initially this had started in Allegan, where Mr. Oliver was initially arrested for a delivery. He was on bond there. And then there was, I think, outstanding issues out of Chippewa where they had not issued warrants on him. I think there was some indication possibly that he was going to work with them and then didn't. And so they just sort of had those set to the side and brought them later. But then ultimately he was arrested here on delivery. And then those charges out of Chippewa County came later. When you're looking at this on paper, it looks really, truly terrible and awful. And I understand that. I'm a realist. I will say though, this is probably on paper and speaking with Mr. Oliver and just knowing what I know about him through the mitigation process, speaking with his fiance, this has got to be one of the worst addictions I think I have personally ever seen in practice. I don't believe that Mr. Oliver was a dealer or dealing just to be a dealer or be dealing. I truly believe that Mr. Oliver was doing this to feed his own addiction. I would say that was probably 99.9% of what the motivation was here. I believe, and I think it's in the mitigation memo as well that the court received, that there's some other type of co-occurring mental health issues going on. And that speaks true, especially in the initial conversations I had with him when he was lodged in Chippewa County. Very ADHD, very, difficult to track. I would say today, speaking with him, he's the best that he's been in conversation for sure. So I think it's done wonders for him to, stop using. But anyway, I think in terms of how it looks, I do think overall the addiction was so out of control. It's almost like being possessed in my mind. I worded it in the sentencing memo, a concentrated burst. And I think that's a good way to describe it. I think absent these addiction issues and mental health care, that Mr. Oliver would not be delivering drugs into anybody's community. With that, Your Honor, and I of course, I make the request in the sentencing memorandum. We are asking for a reduction from the bottom end, the low end of the range. We do have a cap. Now, Allegan counties and Chippewa counties both agreed to run concurrent at 50 months. I would ask the court to think about something in that range. But ultimately, what we're really hoping to achieve is that the court doesn't go above the cap and honors the agreement between defense and the prosecution in terms of that. But I do think with the mitigating factors that have been provided to the court, that there is enough reasons there that if the court were inclined to look at a sentence length below the minimum, that would be reasonable under the circumstances. Thank you, Your Honor. I do believe my client would like to talk as well.
Thank you, Ms. McGregor. Mr. Oliver, you're not required to say anything today, but you're welcome to. Is there anything you want to tell me or no?
I would like to say something. Yes,
Go ahead and stand up if you would.
I've been talked to about things in my addiction that I don't remember. My addiction got the best of me. It was hard coming home. A lot of it was reformity from coming home from Texas prison, not fitting in. And it kind of led in just with trauma as a child. And my addiction got the best of me. I wasn't trying to be no drug dealer or anything like that. I know that I messed up. I know that I was using drugs and I had them in the wrong spot. But I also know that my kids pay the most for it and I was saying the most. I missed my first son's being born. Not my first son, but the first of my children being born. He's got problems with being deaf. And I can't help his mom. And she's got so much on her shoulders. And I don't know what to do sometimes. I mean, I've sat in Marquette for 24 days, hearing guards yell at people, spitting on them, telling them to go kill themselves. And I'm there to be a drug addict. I didn't kill somebody or anything like that. And it hurts, but I'm the one that did it. I'm the one. But I know that this report has made me cry as well through a lot of tears that I've done in my recovery. And I stand by my lawyer and what she asks. That's all I ask, Your Honor.
All right. Thank you, Mr. Oliver. Ms. Goodrich, any recommendations from the people?
Oh, yes, Your Honor. Thank you. The defendant is 35 years old with 5 prior felonies and 4 prior misdemeanors. He's unemployed with a GED. Looks like his criminal history spans from 2017 to 2023 pretty steadily. Then he absconded and ended up in Texas with additional charges. He was paroled April 10th of 2023, and then his next offense date is June 16th of 2024. So not a lot of time off from the criminal activity, and that's when it began in Chippewa, went to Allegan a month later, and then here in Sheboygan in December of 2024. For those reasons, Your Honor, I still ask that you follow the plea agreement to not exceed the 72 months, which would be at the lower end of the guidelines.
Well, thank you, Mr. Oliver. If you please stand for the court sentence. As is almost always the case, there's lots of things going on in this case. You've got on the prosecutor side of the ledger, the stuff that they remind me of that are all true things about your criminal history that dates back, more than a decade and involves, absconding and home invasion, forgery, deliveries, and you were engaged in multiple deliveries in a couple different counties. And then here was a possession intent to deliver of, a fair amount of methamphetamine. Those are all true things. And then, the things pointed out by your attorney in the sentencing memoranda about, the things that have occurred in your life that have brought you to this point. Some of those are your own fault. Some of those aren't your fault, those are all true things too, but the thing that I want you to keep in mind, there's no such thing as a life without pain. Nobody that you meet has a life without pain. Those guards behind you, they've got stories of pain they can share with you. Everybody in this room, it's what you do with that pain. And what you do is commit felony crimes. And then you end up in prison away from your family. And that really sucks for your family. It sucks for you. But we didn't commit those crimes. You did. So the other people around you that have pain in their life, they can choose to do different things with that pain. So, when you're in prison, you told me about one of your experiences of hearing guards interacting with folks. There's a lot of things that happen in prison. There's crimes that happen in prison. There's also programming that's available in prison. So you have a series of choices ahead of you while you're in prison. You've already got a significant prison sentence or a fair prison sentence, and you got a 72-month cap here. So you're going to get a longer sentence here. So you're going to have a bit in there. You're going to have a lot of choices to make over the next 5-6 years. If you make good choices, you're going to get paroled in about 5 years with your credit and get back to that family, and you don't have to keep committing crimes. But you see from the felony record you have, your guidelines here go up to 195 months. So I could give you 15 years in prison right now, and there's very little that anybody would do about it. It's within the guidelines. It's presumptively proportionate. And with the history that you've got, I think that could be a proportionate sentence, right? So when you get paroled, you commit 4 more felonies, you're going to start seeing 10 and 20-year sentences. So in any event, taking into consideration all the information in the pre-sentence report and the defense sentencing memo, I find that there's reasonable grounds for a downward departure from the 78 to 195 months range, and that is the sentence agreement for a 72-month cap. I do take into account the information in the mitigation memo, but I don't perceive that that's grounds to go even further below the sentencing guidelines as requested. So I will sentence you on count 1. I'll commit you to the Michigan Department of Corrections for a term of not less than 72 months, nor more than 40 years, exercising my discretion under the habitual 3rd statute to increase the statutory maximum and give you credit for 296 days previously served. There's a crime victims assessment of $130, court costs of $350, state costs of $136. And then the incarceration on count 2, the tampering with evidence, commit you to the Michigan Department of Corrections for a term of not less than 64 months, nor more than 8 years, again, increasing the statutory maximum under the habitual 3rd statute. And those sentences will run concurrent with each other and concurrent with your other county sentences. And you get credit on both counts for 296 days previously served. I'll dismiss the pending contempt for failing to appear. And Mr. Oliver, that is the sentence of the court. If you wish to appeal, you can file an application with the Court of Appeals. If you wanted a lawyer appointed for you, you'd have to ask me within 6 months. We're going to hand you 2 copies of your appeal rights right now. Ask you to initial 1 copy for us so we have a record we gave it to you. And the other one is for you to fill out if you want to take an appeal. Do you have any questions for me, sir?
No, Your Honor.
Okay, good luck to you.
Thank you, Your Honor.
Under Michigan law, there is a critical difference between simple possession and possession with intent to deliver. By pleading guilty to a delivery offense, Oliver was legally classified as someone engaged in drug distribution, even if the defense argued his actions were driven by addiction rather than profit. That distinction matters because delivery offenses carry higher guideline ranges and greater public safety weight at sentencing. In Michigan, felony cases proceed by indictment or information under MCL 767.1 and 767.3, and once a conviction is entered, the court must sentence within the statutory framework. While the sentencing guidelines provide a recommended minimum range, appellate courts review sentences for reasonableness and proportionality rather than strict guideline compliance. Under the post-Lockridge framework, the judge also has discretion under MCL 769.3 and the habitual offender statutes to accept or reject a negotiated sentencing cap so long as the final sentence remains lawful. In this case, the court weighed the nature of the conviction, the prior record, and the agreed cap and imposed a sentence that reflects how Michigan law treats drug delivery offenses, not just drug use.